All right, let's talk more on this then. Mpumelelo Zikalala is a legal analyst and lawyer at Zikalala Attorneys. He joins us to wrap this week's proceedings in the Senzo Meyiwa trial. So it's always a pleasure to have you here on SABC News.
Good evening to you, and also good evening to your viewers. Thank you for having me.
You're most welcome. The biggest revelation, it seems to be this week, of course, what we heard today, the fact that one of the witnesses in the House was communicating with one of the accused. How important is this revelation to the overall case?
I think it's important, but I think at a much later stage, the bigger picture is then going to be made as to how that communication was crucial, or maybe in the premeditated murder of Mr. Meyiwa. I do not think that the court or the state would want to state this information simply for the sake of stating it. I think, number one, they're driving towards stating at the end of the day that there was a much bigger premeditated murder or plan to murder Mr. Senzo Meyiwa. Secondly, it's to lament the fact that common purpose is driven amongst the five accused.
Yeah.
Remember that there are only two individuals that are placed inside the scene, and then the rest of the three, one wonders how do they link to the whole process. Now, if you're able to link them up through communications and saying that this was a well-planned, orchestrated plan, they were all in on it, it may be that the active soldiers were the two individuals. However, the notorious or the mischievous minds were all five accused that are sitting on the witness box. That is where the doctrine of common purpose would then come in. Also in the punishment would be the same. Maybe that's what the state is driving it at the moment.
Yeah. I mentioned a witness that was in the House, and I'm quite careful to tread, lightly on this issue of Kelly Khumalo. But why would she not have, why would the state not have thought that she's someone to call to the stand? I understand that she wasn't, in fact, on the list of witnesses to take to the stand, and now we're hearing all sorts of revelations linking phone calls to her and the accused, one of the accused. How could the state not have, possibly seen the importance of having what I'll call a main character, taking to the stand?
Well, there are various reasons, but I have three which I think maybe would be one of the three. The first one would be that maybe you are going to be a co-accused or one of the person who's going to be charged at a much later stage. So we would rather not let you come into the witness box because it's not going to add any value. Second one, must also remember that when a person goes into the witness box, the court does not really look at their social standing, for example. So the court doesn't care whether you are the celebrity or not. The most important thing in the court is to say, were you there on the day in question? Do you understand the sequence of events? Do you have first-hand knowledge? And if the answer to that is yes, then we want you to get into that box so that you can give us this crucial knowledge. Now, in this case, you have Senzo Meyiwa who's at the scene. You have another friend that has testified earlier was at the scene, and other individuals that are there. So if they are going to repeat the very same thing of saying that there were two intruders, there were intruders that came in on this particular day, and those facts are not disputed, then the state has ticked the box of providing that crucial information. So it may be on the second occasion or the second option that the court or the state has seen that we can be able to lament these particular facts without having to call Kelly Khumalo to come into the witness box. She's not going to add any value or add any or the cherry on top if she then comes, because the court is not going to say, we are placing high probability value in what you are saying because you are Kelly Khumalo. The court will simply look at the facts and say, were you at the scene on the day? Can you provide first-hand experience? Thank you. We can then move on and accept the evidence that you provided to us. So it could be one of those reasons in which the state is saying, we already have all the witnesses that we want. We do not want you to come in here. Or the third one being that they may see that there may be loopholes in the manner in which the statements that have been provided by her, and they don't want to weaken their case by bringing someone who can bring in loopholes or alternative versions that at the end of the day are going to go against what the state is saying.
Yeah, and we've been obviously hearing about this second docket in the first trial, which we've now moved on to a new trial altogether. There was this talk of this second docket. At which point is it now appropriate to bring up this issue? I mean, the fact that we have someone who was a witness in the House that's possibly named in the second docket, it would seem that the appropriate time would be around now to bring up this particular case, or is it an issue of timing?
I think it would be an issue of time. I would have thought that from the side of the NPA, they would have said, we want to have context of both dockets. We want to merge them together and see what statements are in our favor. from a legal strategy point of view, let's place those witnesses as belonging to us so that they are not game or that can be utilized by the defense. In a later stage, if you can see that there's some perjury that has taken place, either if any of the witnesses are lying, it's going to be easier for us to prosecute them for perjury. But I was a bit amazed as to why do you want to leave a second docket with evidence that you could be able to use when you have a very strong burden of proof, which is you need to prove beyond reasonable doubt that the accused are sitting there, the individuals that really orchestrated this crime. Why don't you want to use information which is available to you? But I think maybe after the 8th or 9th witness of the state, we should be able to see the bigger picture of where the state is driving at. What is the narrative which is then provided by the state?
Yeah.
But it would assist the state in order to state that narrative now, so that when the presiding officer is sitting there and is piecing in all these pieces of information, he's not confused as we are now as to exactly where are we going with this particular matter. I want to know the bigger picture. I want to see the end result so that I can be able to bring in the smaller pieces as we continue to provide this information on a regular basis. If you don't do that, you run the risk of being very difficult to convince the court at the later stage as to the narrative or the probabilities of the narrative that you are trying to bring. And after cross-examination has taken place and they've poked a lot of holes in the story in which you are coming about, it may be a bit difficult to be able to convince the court.
Yeah, the judge at some point raised the fact that, it's common cause that, the incident happened. That's not in dispute. Both sides, both parties agree that, all right, the incident did happen. But the dispute really lies in the fact that, the defense is saying, well, our people, the accused, were not there. Wouldn't the easiest way to prove that, the people that you're defending weren't there is to provide some sort of alibi or provide, if they were not at the scene of the crime, this is the alternative, this is where they actually were. And we've realized that this is an easy process, cell phone pinning, all of that kind of thing. Why is there no offering of an alternative as to, where they could have been? And does that not make the defense's case a little bit, weaker?
You see, that's when the presiding officer was giving the defense crib notes of saying, if you want to convince me that your clients are not the ones that orchestrated this crime, these are the type of evidence which I'm going to look at. Now, as the defense, when you conduct this cross-examination, be careful or remember to put the version of your accused of saying that, or your client, which will then say, on that day, I was not present. On that day, I may have communicated with Kelly Khumalo on the previous occasion. However, we did not discuss anything about this matter. I have not denied that I've known it before.
Yeah.
In fact, it's a question which has not been asked to me. And I was really not forced to disclose this information to you. However, if you really want to check what I was doing, here's a plausible explanation. But it does not mean that if I've communicated with her, then I was colluding in any type of manner with her, or on the day I was really there, utilizing the phones that are there. Another aspect that came in, which maybe would be a defense, the one of saying the interchanging of handsets, because you may find that the handset is registered to a person A. However, with the changing of SIM swaps, it is then utilized by other individuals.
Yeah.
So if you're able to prove to court that, yes, I put the handset registered in my name, however, eventually it was used by this person, I do not know what they were communicating or doing with that particular handset, it then may be able to exonerate you. But remember the burden of proof. It is not for the defense to prove their innocence. They are simply there to provide an alternative narrative, which at the end of the day are going to say there is an alternative narrative that does exist. So on your burden, which is then applicable to the state, you have failed to prove beyond reasonable doubt that I'm the one that participated in this process. Hence why I stated earlier that it would have been much wiser for the state to take the two dockets, match them together, take what works for you and leave what does not work for you, but make sure that you provide enough evidence to be able to come back with the conviction. Because if you leave loopholes and questions which cannot be answered in a positive manner, then the chances of you getting a conviction for all 5 accused is going to be very minimal.
All right, Mr. Zikalala, I wish we had more time. Thanks very much for your legal analysis then this evening. Mpumelelo Zikalala, who's a legal analyst and attorney at Zikalala Attorneys.